investigation could not actually have been limited because the pretrial chamber did not authorize any investigation at all. Its view on the scope of the investigation was merely a step in its reasoning to that conclusion. Nor in any event did the pretrial chamber determine that the incidents which were not specifically mentioned in the prosecution's Article 15.3 request were outside the court's jurisdiction. It merely took the view, albeit erroneously, that they were not sufficiently encompassed by the Article 15.3 request as a matter of procedure. As such, even assuming that the majority was right in this regard, which of course we contest as Ms. Brady will address, the ruling will still not prevent the prosecution from bringing a further request under Article 15 with respect to these incidents, nor preclude the pretrial chamber from granting that request. None of this means that an Article 15.4 decision can never fall within the scope of Article 82.1a. We only say that the decision under appeal today does not. If a pretrial chamber rejected an Article 15.3 request on the basis that there was no jurisdiction ratione loci under Articles 12 and 53.1a, then that decision would be jurisdictional. Or if the pretrial chamber authorized an investigation but limited its parameters based on jurisdictional considerations, then that would also be jurisdictional. I turn now to question B, Your Honors. This refers to whether in interpreting the wording decision with respect to jurisdiction, would this wording include decisions making determinations on the preconditions to the exercise of the court's jurisdiction under Articles 12, or the exercise of the court's jurisdiction under Article 13 of the statute? And our answer here is yes, but only if the jurisdictional ruling forms part of the operative part of a decision, consistent with our answer to question A. In this context, we agree that matters such as the preconditions to the exercise of the court's jurisdiction under Articles 12 and 13 are indeed jurisdictional in the sense of Article 82.1a. Such matters may also arise under Articles 5 to 8 bis concerning subject matter jurisdiction, as the Appeals Chamber has previously ruled in Ntaganda. That's reference 3 in our reference list, Your Honors. Accordingly, we concur, as we stated in our brief, that the scope of Article 82.1a is not limited simply to proceedings under Articles 18 or 19. And this is consistent with the practice of the Court. For example, in the DRC situation, reference 4, the Appeals Chamber allowed an appeal under Article 82.1a with regard to the warrant of arrest for Mr. Ntaganda, a matter arising under Article 58 of the statute, not Article 18 or 19. Likewise, when ruling on appeals under Article 82.1a and deeming those appeals to be inadmissible, the Appeals Chamber has looked objectively at the reasoning and disposition of the challenged decision and not simply excluded the appeal because it did not arise under Article 18 or 19. For example, the Appeals Chamber considered whether Article 82.1a could apply in the context of matters brought under Rule 103 or Article 95, this is the Gaddafi case in reference 5, Article 93, the Katanga case in reference 6, or Article 53, Comoros, reference 7. And it is precisely because a variety of legal issues may be said to be jurisdictional in nature that it is important to maintain the requirement for the operative part of the decision to rule on that jurisdictional issue in order to trigger Article 82.1a. Otherwise, the Appeals Chamber might be directly seized of a wide variety of interlocutory appeals. In conclusion, Your Honors, while we agree that jurisdictional matters are addressed in the pretrial chamber's decision, we do not agree that the operative part of the decision, that part which is dispositive, address those jurisdictional matters. And it is for that reason that we did not consider that Article 82.1a applied to the situation. Now, I will turn now to Group A of Your Honor's questions regarding standing. And your first question in this group, question A, is whether victims should be considered parties in the proceedings under Article 15 in comparison to other phases of the criminal proceedings. And our answer, Your Honors, here is no. While victims are expressly given a right to participate in Article 15 proceedings, this does not convert them in parties. And indeed, with the exception of reparation proceedings, owing to their special nature, it is well accepted that the statute provides for a general approach to victim participation, which ensures that they have full opportunity to address relevant substantive issues before the court, but does not impose on them the rights or the obligations of the parties. This holds true for criminal trials and appeals, which are the main judicial proceedings of this court. It therefore stands to reason that the same principle would also apply in those proceedings where, by virtue of their limited and more preliminary nature, the concrete interests of particular victims will not yet be manifest, such as even before the prosecution has begun its investigation. And indeed, Your Honors, there is simply nothing to support the view that the drafters of the statute conceived proceedings under Article 15.3 or 19.3 as establishing broader participatory rights for victims than under the statute more generally, such as under Article 68. And indeed, the ordinary meaning of the word representations is consistent with the ability of victims to address the court on the substance of the issues at hand, which is the essence of the participation regime. This is contrasted with the status of the prosecutor, who has exclusive right under Article 15.3 to seize the pretrial chamber, based on her own independent preliminary examination. It is consistent with this exclusive right, as already said, that the prosecutor also has exclusive right of appeal. But the statute also makes clear, in provisions such as Articles 42, 54, and 68, that while independent, the prosecutor must be mindful of the interests of victims at all times. And the Office of the Prosecutor itself has given effect to this principle in its own internal procedures, such as its victim participation policy from 2010 and its regulations of the Office of the Prosecutor, like Regulations 16, 37, and 52. For all these reasons, victims should be afforded the same status for the purpose of Article 15 as they enjoy for all other proceedings before the court, with the exception of reparation proceedings. That is to say that while they do not have the procedural rights of the parties, their participation on substantive matters is a right afforded to them by the statute, and its exercise is to be welcomed and supported at all times. Moving to question B, Your Honors, and here the question links to whether the existence of a limited group of people who can challenge, or actors who can challenge the jurisdiction of the court under Article 19.6 or seek a ruling of jurisdiction is also linked to a right to appeal that decision under Article 82.1a. Now, we have already explained, and I will not repeat myself, why a decision under Article 15.4 is not necessarily a decision with respect to jurisdiction, not this decision. At the same time, Your Honors, Article 82.1a, and as I also have mentioned, is not necessarily limited only to decisions arising under Article 18 or 19 of the statute. So the answer to this question is again no. Article 19.6 limits those persons who may be considered as parties to appeals arising to an Article 19 decision, but it does not apply to appeals under Article 81a arising from other kinds of decisions that also are jurisdictional in nature. So as such, Article 19.6 does not resolve the issue arising in this appeal today. In our view, Article 82.1a forms part of a comprehensive provision regulating the rights of the parties to appeal decisions other than convictions, acquittals, or sentences. Victims, as already said, do not fall within the parameters of the 10 parties and therefore cannot invoke this provision. Article 19.3 defines the circle of potential actors who may lodge challenges to the jurisdiction of the court or the admissibility of a particular matter. And this includes a state that claims to have jurisdiction over a case or a state from which acceptance of jurisdiction is required under Article 12. And Article 19.6 makes clear that these actors may appeal such decisions, which would fall under Article 82.1a. So Article 19.6 is therefore lex specialis to Article 82.1 in the sense of defining these actors as parties for the purpose of such appeals under Article 82.1a.
Excuse me, Counsel, you have 5 minutes left.
But for obvious reasons, Article 19.6 has no effect on appeals under Article 82.1a, but which do not originate in Article 19 proceedings. Turning to question AC, Your Honours, the question here is whether the right to make representations under Article 15.3 entitle victims to appeal a decision under Article 15.4 of the statute. And again, our answer is no, and I will be very brief here. There is nothing in the statute that could somehow support the conclusion that victims making representations in a confined and self-contained process taking place at the beginning of an investigation can have broader procedural rights than victims' fully participation in the litigation of a case before chambers of the court. On the contrary, Your Honours, the architecture of the Rome Statute shows a progression in the degrees of participation in victims in proceedings before the court, ranging from a limited right to make representations at the inception of an investigation to a right to fully participate in the context of a case being litigated before the court to becoming a full party in the context of reparations proceedings. I will move to the last point, Your Honours, and the question here is whether in light of Article 21.3 of the statute, does the international recognized human rights of access to justice and to an effective remedy entails a right for victims to appeal a decision under Article 15.4 of the statute. And here again, the answer, Your Honours, is no. To begin with, Your Honours, we think that the right as such to an effective remedy has to be properly contextualized to the situation of this court within the framework of Article 21.3. And in this context, the right must be understood to be primarily opposable to states, not to this court. And we reach this conclusion for the following reasons. First, Your Honours, and as it should seem obvious, the court is not placed in a situation comparable to that of a state vis-à-vis its own citizens. This means that any importation into the context of the court of positive duties placed by human rights law on states should be mindful of this crucial difference as well as of the court's unique nature and mandate. And international law does indeed recognize that victims have a right to a remedy, as in the sense recently described by Judge Ibáñez in Lubanga, and that's reference 8 in our reference list. And this involves both the right to petition to the authorities, or the procedural right, and a right to obtain redress for the violation, a substantive aspect.
Excuse me, Counsel, could you slow down a little bit?
Will do.
Because there's a problem with the interpretation.
I will do, Your Honours. I apologize. But by contrast, Your Honours, this court was created by states as a mechanism with a selective mandate. This is an unavoidable fact, both as a consequence of the legal regime in Articles 11 to 17, 53 and 54, and 58 of the statute, and the sheer practical reality of the court's limited capacity. So for the cases which fall within the court's mandate and which can be properly brought to trial by the prosecutor, then this may discharge the state's obligations. But when matters are not addressed by the court, then the obligation remains with the state. And as such, the victim's right remains opposable to the state and not to the court. This is the flip side of complementarity. Now, in this context, if victims do not have an enforceable right to have a particular case investigated at the court, then necessarily they do not require standing to appeal in order to make sure that such right is effective. But beyond that, Your Honour, again, human rights bodies have recalled a number of times that it is sufficient that victims have effective access to the investigative procedure for the remedy to be granted. And here, Your Honours, they can make submissions to the Office of the Prosecutor and to the Chamber. And Your Honours can find those referenced at number 9 of our list. So even if Your Honours here consider that the right to an effective remedy is opposable to the court, this right could be satisfied by the existence of an independent prosecutor before whom victims can make representations and who is able to bring suitable proceedings on the basis of those representations. It does not require the grant of standing to the victims themselves. This approach, Your Honor, is consistent with existing human rights treaties, whereby the ability to bring the matter to a competent organ for action is adequate to satisfy the right to a remedy. For instance, the ICCPR recognizes that the remedy may be determined by competent judicial, administrative, or legislative authorities. According to this, the possibility for a public agency to act on the victim's behalf may suffice, and the Office of the Prosecutor is precisely such an agency for the purpose of this court. The same goes for the European Convention, which requires a remedy before a national authority, and the African Charter, which requires recourse before a competent national organ. Your Honor, this concludes my submissions for this morning. I apologize for the speed. Thanks, Your Honor.
Thank you, Counsel. I would like to invite the representatives of victims Group 1. Everyone, your 30 minutes begins now.
Thank you very much, Mr. President. For centuries, the people of Afghanistan have gathered to administer justice in jirga and shura in accordance with ancient traditions and the Holy Quran. Justice is at the core of religious and traditional beliefs of Afghans. For 4 decades, Afghans have endured one armed conflict after another. These have left too many Afghans mourning the loss of their mothers, fathers, brothers, and sisters. When Afghanistan joined this court in 2003, the Rome Statute system became part of Afghanistan's legal framework and presented a set of legal remedies that Afghans have a right to access. Today, after a preliminary examination that lasted 11 years, followed by 17 months during which the pretrial chamber considered the prosecutor's request to start an investigation, the court is holding its first hearing on the Afghanistan situation. It concerns issues of critical importance, not only to the victims that we represent, but to all Afghans. It has been a very long journey for the victims until today, but today is a historic day for accountability in Afghanistan. The 82 victims that we represent belong to various Afghan groups. They live in diverse parts of Afghanistan, and they speak different languages. They are victims of crimes allegedly involving different actors. Whatever their differences, they are united in their wish for an investigation to begin promptly into the crimes committed against them. We are here to challenge a decision that has extinguished all of their rights under the statute and has caused enormous damage to any hopes they have for justice and accountability. Many of the victims we represent are mothers with children. Your Honour's decision in this case will in no small way define whether those children grow up in Afghanistan characterized by the rule of law or by a culture of impunity. The interests of the victims and the prosecution do not always coincide. We're all agreed on that. It is critically important that victims have an independent right to appeal a decision that presents a clear and extreme danger to their rights. It is also important that victims can present their own grounds of appeal when appealing such a decision. The prosecutor has many issues to consider: the resources available to it and its position in other situations. It has to balance its obligations to different groups of victims within and across situations. These competing considerations were brought to the forefront by the prosecutor herself in an address to the Assembly of States Parties 2 days ago on the 2nd of December 2019. She said that, quote, "One key question that my office will need to tackle in the coming period is the reality that a number of preliminary examinations will likely progress to the investigation stage, but we will not have the operational capacity to absorb them all. As such, we are considering how prioritization might apply across different situations," unquote. In contrast, the interests of the victims are limited to one situation, the Afghanistan situation. The legal representatives of the victims are under a duty exclusively to represent their interests of their clients in this situation. They have no other interests to defend in accordance with their obligations under the Code of Professional Conduct for Counsel. I will now address Your Honour's questions under Groups A and B. I will begin by addressing together questions AA, AB and AC, which concern standing to appeal a decision. The Rome Statute recognises the interests, views and concerns of 4 principal actors. Those are the prosecutor, the defence, whether as suspect, accused or convicted person, states and victims. The statute allows these 4 actors to defend their interests and to express their views and concerns through various procedures at different phases of the proceedings. Interlocutory appeals are, of course, regulated by Article 82, and all interlocutory appeals, regardless of whether they fall under 82.1a or 82.1d, may be appealed by, quote, either party, unquote. An ordinary reading of either party does not expressly limit interlocutory appeals to any particular one of the 4 parties I identified. Articles 18 and 19, read together with Article 82.1, make it clear that at least 3 parties, that is to say, an accused or person for whom a warrant of arrest or summons has been issued, a state in certain circumstances, and the prosecutor, can be considered a party for the purposes of 82.1. But the expression either party is not limited to those 3 parties, nor is Article 82.1a limited to decisions under Article 18.4 and 19.6. The Trifter commentary recognises that, quote, other decisions that are potentially appealable under Article 82.1a include, for example, those under Article 15.4, close quote. The presence or absence of an express right to appeal is not determinative of standing. Some provisions, such as Article 18.4, expressly provide for a right to appeal for a state. Article 87.7, on the other hand, does not provide for an express right of appeal for a state referred to the UN Security Council or to the Assembly of States Parties. But nevertheless, in the al-Bashir case, Jordan appealed an 87.7 decision on the basis of Article 82.1d, and the appeals chamber quite properly, if I may say so, considered the merits of that appeal. In determining whether one of the 4 principal parties in the statute have standing to appeal a particular decision where no express right of appeal exists, I submit that the appeals chamber should consider 3 factors. First, whether the statute recognises the participation of the applicant at that stage of the criminal proceedings. Second, whether the impugned decision is highly prejudicial to the interest of the applicant. Third, whether hearing the appeal will result in unfair prejudice to any other party. All three of those requirements are satisfied here. First, the pre-authorization stage, which is addressed in Article 15 and Rule 50, only envisages the participation of the prosecutor and victims. The Appeals Chamber recognised in its decision of the 24th of October 2019 in this situation that Rule 53, quote, highlights the importance of victim participation in the procedure for authorization of investigation, close quote. Second, the impugned decision was extremely prejudicial for the victims. A decision denying authorization affects every victim of every crime, of every potential case arising out of the situation. Where victims are denied an investigation, they are, without exaggeration, denied everything. All of those victims in all cases in the entire situation are denied the realization of their rights recognized by this court to truth, justice, and reparation. Now, Mr. Guarilla, in his submissions, made a distinction between victims of a case and victims of a situation. But the impugned decision here is more consequential to the victims of a situation than a decision which might, for example, acquit all accused in one particular case, or a decision to award no reparations or a derisory sum of reparations in a particular case. Those decisions apply to a specific case. They don't apply to the entire situation. So in our submission, a decision to deny investigation in a situation is in fact the most consequential decision for victims. There's no decision which can be more prejudicial to their rights. Third, there is no unfair prejudice to any other party should the Appeals Chamber recognise the standing of victims. In particular, there's no unfair prejudice to the prosecution. The prosecution's submissions concerning its floodgates argument have no merit. In its 22nd October response to the appeals by the victims, and again today, we've heard the prosecution refer to the possibility of NGOs, states which don't have an interest in the proceedings, potentially even members of the public with a grievance against a decision of a pre-trial chamber coming along and clogging up the appeals system and wasting Your Honour's time. That is simply an entirely overstated and misconceived argument. The prosecution itself, in its 2019 to 2021 strategic plan, has restated its position that, quote, under the Rome Statute, victims are actors of international justice rather than its passive subjects, close quote. They fully meet all requirements of a test for standing which the prosecution itself asked the Appeals Chamber to consider. And I refer to our submissions on this point in our 29 November 2019 response to the amici curiae. The victims are not strangers to these proceedings, nor do they suggest that strangers to the proceedings be allowed to appeal as of right or indeed at all. Your Honours, I turn now to question A.D. In this question, Your Honours referred to the fact that victims have an internationally recognised right to an effective remedy and access to justice under Article 21.3. You've asked if this includes a right to appeal the impugned decision. And we say, yes, it does. The Appeals Chamber, Your Honours, are required by Article 21.3 to interpret and apply every article of the statute, including 82.1a, in accordance with the rights which Your Honours identified. The victims here would very well pursue another remedy if they had one. They don't have one. Over the course of its 11-year preliminary examination, it became clear to the prosecutor that states in a position to exercise jurisdiction are either unwilling or unable to do so. The pretrial chamber reached the same conclusion. We submit they were right about that. The recent submissions presented by the government of the Islamic Republic of Afghanistan show only that it remains unable to effectively investigate or prosecute. This applies even if Your Honours accept that it is willing to do so, which is an open question. The only jurisdiction in the world, without exaggeration, that can offer the victims a prompt and impartial investigation into the brutal crimes committed against them is this court. The only way the victims can exercise their right to an effective remedy is to appeal the impugned decision. I'd like to address very briefly a point raised by my learned friend, Mr. Guarilla, that however desirable victim standing might be, we need to leave that up to the Assembly of States parties. And I would suggest that that is not well-founded, and it is not consistent with the purposive approach which this appeals chamber has taken to the statute. Your Honours, not necessarily this bench, but the appeals chamber has interpreted the statute purposively on many cases. The no case to answer procedure appears nowhere in the statute or rules of procedure and evidence, and yet it now exists at this court. The duty to be present at trial is absolutely clear in the statute, and yet it has been recognised in Ruto that an accused can actually be absent for very large portions of his or her trial. The lack of ability to issue a binding order to a witness to appear to testify was one of the great weaknesses of the Rome Statute, and the appeals chamber cured that weakness. And it also cured the absence of a duty on a state to ensure that a witness appears to testify. The stay of proceedings which arose in Lubanga proceedings, that doesn't appear in the statute either. So there are many cases where this appeals chamber has upheld purposive interpretations of the statute. The statute is a living document, like the European Convention on Human Rights, and it should be interpreted as a living document intended to provide realization of the rights of those of the victims. Now, Your Honours, I want to turn now to the questions on jurisdiction. In response to question BA, the answer we submit is yes. There's no binding jurisprudence, obviously, on the question of whether a decision to deny investigation is a decision with respect to jurisdiction. The closest we have are some decisions which are essentially decisions about admissibility. The appeals chamber's decision in the Kenya situation emphasises that the right to appeal a decision on jurisdiction or admissibility is intended to be limited to rulings specifically on the jurisdiction of the court or the admissibility of the case. The appeals chamber also cautions that it's not sufficient that there is an indirect or tangential link between the underlying decision and questions of jurisdiction. Now, here the trial chamber made determinations specifically on the jurisdiction of the court. The link between the underlying decision and these questions of jurisdiction is not indirect, it is not tangential, it is direct. This is for three reasons. First, the decision deprives this court of the possibility to exercise jurisdiction over any cases which might arise in the Afghanistan situation. That's very far-reaching. Every chamber of this court is deprived of jurisdiction. The prosecutor is deprived of investigative jurisdiction into all crimes in the situation. Second, the decision contains serious errors concerning the territorial jurisdiction of the court over torture, and indeed that applies by extension to all war crimes, requiring the court to find that the conduct, quote, took place in the context of and was associated with, unquote, an armed conflict. And that applies, of course, to every war crime in Article 8. Third, the pretrial chamber erroneously attempted to impose limits concerning the scope of the court's jurisdiction in any authorised investigation. Its limitation on the scope of the investigation, two incidents specifically mentioned in the prosecutor's request, is a determination with respect to jurisdiction in three ways: temporally, territorially, and in matters of substance. Mr. Guarilia referred to the decision of Judge Eboe Osuji of the 2nd of September 2019, the Comoro situation. I respectfully agree with Judge Eboe Osuji's analysis there. It's important that the appeals chamber retains control over what is and is not a decision with respect to jurisdiction. Your Honours do not have to be totally hung up on exactly what the operative part of the decision might say, whatever that operative part might be. In this case, the operative part certainly deprives, as I've submitted, the court of jurisdiction over every case in the Afghanistan situation. That's its effect, that's the nature of the decision. Now, Judge Eboe Osuji has emphasised that the deciding chamber can't be that one which decides whether it's a decision on the exercise jurisdiction. It can't control the appeals chamber's ability to consider that decision as really being with respect to jurisdiction. That cannot be right, he says, and we respectfully agree. A decision with respect to jurisdiction is, on a common sense application, the kind of decision which should be subject to appeal as of right. It is an incredibly consequential decision for the prosecutor, for the victims. It is something which should be subject to appellate scrutiny. It's not something minor, such as whether the parties should have to produce an in-depth analysis chart or something like that, which has taken up appellate scrutiny. I turn now to question 8B, In response, we submit that determinations regarding territorial or personal jurisdiction over Article 12 or decisions regarding the exercise of the court's jurisdiction under Article 13 are indeed decisions with respect to jurisdiction. Articles 12, 13 and 15 all fall within Part 2 of the statute headed Jurisdiction, Admissibility and Applicable Law. They all fall within Chapter 3 of the Rules and Procedure of Evidence. The heading of Chapter 3 is Jurisdiction and Admissibility. I submit that that header was chosen deliberately. One of the sections of that chapter relates exclusively to initiations of investigation under Article 15. The chapter also covers Articles 12 and 13. So at least if using those as sources, we can see that decisions with respect to jurisdiction and admissibility should cover decisions under 12, 13 and 15. Now, it's important that the appeals chamber, and I'm sure there'll be no dispute about this, always does and always must retain a discretion to reject an appeal which is an abuse of process, even if it might technically fall within Article 12, 14, 15 or any other article. An appeal filed for frivolous or vexatious reasons, such as one of negligible prejudice to the applicant, or one which is unfairly prejudicial to another party, can and should be rejected in limine on a case-by-case basis. In my submission, Your Honours, and every appeals chamber has always had that power. And over the years since the court became operational, over 15 years ago, there really has been a very low level of vexatious applicants, and the court has tools at its disposal to deal with vexatious applicants, and it should use those tools. Correcting errors concerning the court's jurisdiction over Rome Statute crimes at an early stage of the proceedings is consistent with the approach of the appeals chamber in Ntaganda on the 22nd of March 2016, where it twice emphasised that, quote, issues as to the court's jurisdiction should be resolved as early as possible in the proceedings. It's absolutely correct for the appeals chamber here to let states parties understand from an early stage the extent of the court's territorial jurisdiction in the Afghanistan situation. It's pragmatically the right thing to do, to clear the air for all parties, for all states, in relation to major questions of jurisdiction at an early stage in the situation. There are, let's face it, not going to be very many appeals against decisions to deny authorization to the prosecutor to initiate an investigation. We're here in 2019. This is the first time this has actually arisen. How many times is it going to happen in the future? Probably not that many. It's the kind of things which should be subject to appeal as of right. It would be a tremendous error to limit appeals on jurisdiction to decisions in relation to Articles 18 and 19 only. I turn now to question B.C. Our response to this, and this is my final submission, is that when the pretrial chamber limited the scope of the investigation, this was a determination with respect to jurisdiction. Each Article 15.4 authorization decision is required to examine jurisdiction in two ways. First, it's required to examine the court's temporal, territorial, and substantive jurisdiction over the alleged crimes. The admissibility of the situation is another analysis. And then second, it has to re-enter the jurisdictional debate and satisfy itself that it is ordering an investigation on suitable temporal, territorial, and substantial jurisdictional areas.
Excuse me, Counsel, you have 5 minutes left.
Thank you very much indeed. So those are two major areas of jurisdictional analysis, each of which requires analysis of temporal, territorial, and substantive jurisdiction, which must be carried out in each decision on an application for authorization to investigate the situation. A perfect illustration of this is the Article 15 decision concerning Myanmar of 14th November 2019, where that pretrial chamber strikingly took a very different approach to the Afghanistan pretrial chamber. In their decision, the two decision sections on jurisdiction took up about 60% of the pages of the decision itself. It plainly was a decision with respect to jurisdiction. Nobody can reasonably insist that it was not. And if the Myanmar-Bangladesh decision was a decision with respect to jurisdiction, so is every other pretrial chamber decision which authorizes or refuses to authorize the commencement of an investigation. That ends my submissions. Thank you very much, Your Honours.
Thank you, Counsel. So we are on time, and I think we will adjourn for 30 minutes break now and resume at 11:30. Which time will be here from the Council, from the legal representatives of Victims Group 3. As I understand, there are 3 teams representing LRV 2, and councils, you can, of course, share time allocated to you. There will be everything after the break. Thank you.
All rise.